William, hopefully your favorite videographer from Two Hats Publishing. I welcome you to another Two Hats special of community events. Let's look in and see what's really happening.
Good afternoon and welcome to Lambda Weekly. I'm Dave Taffet. I am here in the studio with the late Patti Fink, who's on time but actually late for last week's show, and Lerone Landis, who's the late Lerone Landis, and I guess he's not here today. But we do have a guest, and our guest is attorney Rebecca Covell. Rebecca is not crooked but not straight. We'll try to figure out what she is. And that's today's show.
Yay.
Welcome, Rebecca.
Thank you. Glad to be here.
You know, we've talked a little bit, Patti, about what marriage means to us and how much it means to us. And we really, in this whole year and a third, I guess, since marriage equality, we haven't really talked about, okay, what does it mean? What doesn't it mean to be married? What do we have to look out for? What do we still have to do to protect our relationships? And maybe what we don't have to do. So welcome, Rebecca. And give us a little bit about marriage equality and what it means legally for us.
Well, that's a wonderful way to start this conversation. But you got to remember that a lot of us know what marriage means because, of course, we have all of those straight role models that we've grown up with. It was not having models for being a non-traditional couple. We never had any role models for how to be a same-sex committed couple with no ground rules. So we all made our own rules. And those changed dramatically when the Supreme Court, I mean, it's a product of many, many years of struggle and challenge and pushing on behalf of, well, the people in this room and in our entire community to get there. But now we have Supreme Court cases who have ruled that it's the law of the land that same-sex couples are also entitled to all the rights and benefits of marriage. So we're just coming to realize what that means and how it changes the complexion of our relationships. But the Windsor decision in 2013, as many of you recall, is the Supreme Court saying that if you were able to get married in one of the first 1 or 2 and then 5 or 7 and then 13 and then 15 states that would allow their citizens to marry, then the federal government was going to recognize you as a married couple for all federal purposes. So that imbued on those few states' citizens, same-sex couples, 1,138 marriage rights. But then it took another 2 years before the Obergefell decision, where the Supreme Court, just that's the one you mentioned at the outset, in 2015 ruled that if you're married, you're entitled to be married and have your marriage recognized across the country.
Okay. Patti, should we see how smart she is?
Oh.
Okay, 1,138 rights.
You want me to name them?
Name them.
We don't have time.
I was going to say, how long is this show?
What are some of those nature rights? Then what are some of the things that we assume we have being married and really don't have?
Those are good questions.
I know they are. And I worked on them for...
That's why you're running this show, David. That's why you run it, so sort of. So
sort of being the operative word there.
Among the 1,138 really key rights that we have really depends on your status and your relationship. For example, if your spouse is a non-citizen, you have immigration rights to sponsor that person as your spouse. Mm-hmm. That's huge. As a married couple, you are entitled, if you've been married for 9 months, to Social Security from your spouse. If your spouse should die and their Social Security benefits were greater than your own, then you would be entitled to the step up to the higher benefits. It also means, of course, that you have to file as a couple when you file your taxes, and you have extraordinary rights when it comes to estate planning if you're a high net worth couple. Now, most of us don't have over $5.4 million in assets, and our spouse doesn't have... Stop giggling over there, Patti.
Well, because, I married Aaron for money. Yeah.
We all knew that. We called it gold ticking, but I wasn't going to say it.
Okay, and we can talk a little bit about their case separately, but...
And I hope she's listening. I love you, sweetie.
No,
we don't have crap. We don't have anything.
But you got love, baby.
We got love, yeah.
But back to the point, and I did have one, is you do have extraordinary estate planning opportunities because a married couple each takes their $5.4 million exemption into their marriage, and when the first spouse dies, if your assets should maybe even be more than the 10.8 combined exemptions, you get an unlimited marital exemption. So if you're Warren Buffett when the first spouse dies and you just left everything to your wife, no estate tax due when you pass away. But of course, as is true, so there are just so many gotchas in the tax code. It's not that the tax goes away. It means it has to be paid when the surviving spouse dies. So you have to do proper planning. If you're one of those lucky people, the 1/10 of 1% of the people in this country who have that kind of assets, you've got to do some tax planning. So otherwise you're going to be tipping the IRS when one of you dies.
Okay, so... let's just talk about some of those things that we used to recommend that couples do that we no longer recommend they have to do at all, do we?
Well, I just want to inject something because you can remember when, like back in 2005 when we were doing this fight in Texas, and people were saying, the right wingers, the people who wanted to deny us those rights, and in fact we had a Superdome in Texas. They would say, well, you can just go out and get documents, and you can just go and get some documents and it's done. But that's not true at all. I mean, it's like Social Security, like you just mentioned. No lawyer can deem us Social Security benefits out of the blue.
Well, that's true. And another good example was, your employer will let you put your partner, domestic partner, on your health insurance benefits. Yeah, but if you're not married, that is taxed to you as income. So you get to pay all of the taxes on the value of those health benefits. Now, as a married couple, you can put your spouse on if your employer offers it, you can put your spouse on your health insurance plan, and it's not a taxable consequence to the employee spouse. So,
and what made it even worse was, let's say, you're self-employed, Rebecca, so if you were putting your wife, who was then your partner, on your health insurance, not only did you get to pay for her health insurance, you're not asking your employer to do it, you are the employer, not only did you have to pay for her health insurance, but then you had to pay tax on what you were paying her.
You win one way and you win another. But you forgot the operative word, and that is my spouse.
Yes.
She is now your spouse. Yeah.
And she's worth every penny.
And more.
See, it's nice to have guests who love their spouses. Because we're constantly on the air reminding our spouses, not that mine listens, but yours does. And, Aaron, we love you.
What's not to love, right?
Right.
Okay, so there were 7 papers.
7 documents.
7 documents that you recommended couples have. Of those, are any of them no longer necessary? Are they all necessary? Are they necessary in a different format now?
Well, that's a good question. It's that you still want to consider having those significant 7 documents I've talked about for years. And the reason is, now that your marital status is changed, it doesn't mean that the need goes away. It just means you still have to prove your marital status. So do you want to prove your marital status the long way around the barn and rely on the default rules in the Texas Estates Code that I'm the spouse and I'm entitled to this or that or the other, which is a very extraordinarily expensive process to have to go through if you don't have a will, for example. But if you have a will, then your spouse gets a lot of additional rights because of their spousal status. So having these documents, it's like greasing the wheels and making it easier on the spousal survivor.
Okay, so one of those would be the papers for ownership of the yacht. Or is that not where you usually start with your part?
It's usually not where you start. I hope you have a prenup if you got a yacht.
Oh, okay. Well, we do.
In the tub.
But let's talk about medical decisions or making decisions when someone dies. Before these Supreme Court decisions that allowed same-sex couples to enjoy all these spousal rights, they oftentimes couldn't even make a medical decision for their domestic partner. So you'd have a medical power of attorney. Well, I still do medical powers of attorney, and I do it for married couples, not because the law doesn't recognize the spouse as the primary person who could make a decision, but so that if you're traveling together and you're both incapacitated, you've already designated your alternate, so that you know who in your family, and the judge or some court is not going to be getting involved in your affairs to decide, well, do you remember the case out of Florida when Terry Schiavo became so incapacitated?
Do you want the story about that one? That was about the time my father got sick and passed away. So he's in Florida, and he went into the hospital. The nursing home he was in called me on Friday, said, we took him to the hospital. Just having a little bit of discomfort. We'll call you Monday. Shouldn't be a problem. Monday, I got a call from the hospital. Where is your father's wheelchair? I said, what wheelchair? Well, how did he get here? I said, he walked in. Walked in? That's impossible. We're talking about putting him into hospice. I said, whoa. I said, before you do that, first of all, don't you have to have approval from your governor to cut off the life support?
Congress,
so at Boca Hospital, worst hospital, this isn't libelous at all or slanderous, worst hospital that I have ever been in, Boca Raton Memorial Hospital, in May, when nobody's there during the summer, so they weren't that busy. They weren't that busy. No, well, in South Florida there is. During the winter, when the streets are packed and every apartment is full, yes, there are a lot more people in the hospital. In May, no. So I said, don't do anything until I get there. And I said, in the meantime, we'll find out whether Jeb Bush approves of this. So I called Jeb Bush's office. I got hung up on 3 times because I was asking for approval. I said, I understand in your state, and my father's in the hospital in your state, and but they kept hanging up on me. I never did get an answer.
Well, that's because you weren't the spouse, you see.
But I was the son.
But the Terry Schiavo case was, it came about, and it was a married couple, and she was incapacitated, and the husband wanted to, he said, well, you know, while Terry could communicate, she made the decision that she didn't want to be kept alive artificially with these machines and such. And so I want to enforce her rights. And they go, wait. And that could have been avoided, even though they were a married couple. There wouldn't have been this huge argument between him and the parents.
Right.
And there wouldn't have been an argument that went clear to the governor, as you just mentioned, and up to the United States Senate, and then back down to the state of Florida. None of that would have occurred.
We're just turning an extra mic to you
because it's so important?
It sounds better.
Oh.
Actually, the sound is better now. Good.
None of that would have occurred had Terry signed a simple document called, in Texas, a Directive to Physicians, Family, and Surrogates, known as the Living Will. So it's just that you avoid a lot of the red tape and all of this bureaucratic BS that might go on if you have these documents, married or not.
Now, I hope to become a great burden to the state of Texas, and I want to be kept alive by all artificial means. Well, no. Right now I'm a great burden to all of my friends. I hope to extend that to the entire state.
And listeners.
And listeners, yes. In my father's case, nobody asked me for a medical power of attorney. Nobody asked me for any information. In fact, the assumption was, before I even got there, we're putting him in hospice and ending all life support. And it wasn't that bad. I mean, he was still awake and aware, and we had a conversation when I got to the hospital. It's like, whoa, what do you, and I said to the nurse who came in, I said, can I see the doctor first before we decide to put him in hospice? I mean, they were just wham, bam, you're in hospice, and that's, are they supposed to look for that medical power of attorney? What is how do you use that medical power of attorney? Well,
that was a key document for an unmarried couple because it's the document that gave you legal standing to wave that around, and, except in Florida, to wave that around and say, I am the medical agent and I have legal authority to make this decision for partner, right? Well, in a situation where you have a married couple, because that's the paradigm that all of these hospitals are used to dealing with and have dealt with for generations, is, oh, you're the spouse, oh, you're the son, our laws say you are next of kin. And so there they're so busy, they're so nutty, they don't think to go back and say, well, maybe this is the estranged son, or maybe this is the separated spouse, and can I see a medical power of attorney, which would be the appropriate thing to ask for.
Okay.
But it is a double standard. We know that if we were to go in and say today, hopefully this doesn't happen, but it could in Texas. You're in an accident and your spouse has been taken to the ER, and you arrive frantically wanting to know how they are, and they say, "Who are you?"
Right.
And we say, "I'm her spouse."
Yeah.
Well, show me.
Right.
But they don't do that for straight couples.
Right.
And again, using my father's example, he never showed a marriage license when he put his second wife, after my mother died, he got remarried. They were married for 17 years. When he put her in a nursing home, they had never said, well, are you actually married?
Right. Did you have a copy of your marriage license? Right.
Do we still have to prove? I understand when some states had, some states didn't have. We're here in Texas. Some people are going to recognize, some people aren't going to recognize. But I haven't had anybody question my being married to Brian since we're married, even here in Texas. I also live in Oak Lawn, do a gay radio show, work for a gay paper, so there's no reason to. But there's been no question. Do you think we still have you heard of instances where people are being asked to show a marriage license? You're married, go prove it.
Yeah. Have you been to Mississippi lately? Have you been to Alabama lately?
No.
North Carolina lately?
Right.
So there are states, there is pushback to marriage and marriage rights, and those are just 3 examples. I mean, the Chief Justice in Alabama has declared that they're not going to follow the Obergefell and other Supreme Court decisions because it contravenes their religious beliefs. Mm-hmm. And so he is ordering the judges in Alabama not to recognize marriages. So
what's the official religion of the state of Alabama?
I'm sorry?
What's the official religion of the state of Alabama? We're just insulting everybody. I just mentioned worst hospital that I've ever been in my life. That would be Boca Raton.
Yeah, but
I mean, our attorney here is going, no, please don't say that again.
It rhymes with.
Rhymes with.
Roquefon.
It's from the town just south of Delray Beach.
This show has a long history of competing of a competition between Texas and Mississippi. Mm-hmm. We've been doing this for years. Which one's going to be at the bottom?
The 50th out of 50.
Yeah.
Right. We need to take a break. We're talking to Rebecca Covell, the attorney that's neither crooked nor straight. Got it right that time?
Pretty close.
Pretty close. Okay. We still haven't figured out what the hell she is. Maybe we will after this break.
Hey, I'm Giancarlo. You're listening to Lambda Weekly on 89.3.
And I'm Dave Taffet, and this is Lambda Weekly. I'm here with the late Patti Fink, and the extra late Lerone Landis will be back next week.
I guess.
Okay. We're talking to Rebecca Covell. She's an attorney. She specializes in stuff that puts families together.
Don't call it specializes. That's a term of art when you talk to lawyers. My area of practice or focus of my practice is estate planning.
There you go.
Wills and trusts and powers of attorney.
And stuff that puts people together. Yeah. You don't go to her for a divorce.
That's true. I stick people together.
She puts people together. So... okay. Let's just go through what are some of the documents that we need. We were talking just before. We might need our marriage license, but that you get from the county. But
right.
With an attorney, you do documents that you put together. So one would be the medical power of attorney that we were talking about. One would be your will.
That's true.
What are living will?
That's the third one.
But I just want to make a note about the living will. I think it's really important that lots of us, as we see just on Facebook among our friends, our age group, people are going, "Oh, my mom passed away, or my dad fell," or it's happening. Lots. Of
I know as you people age.
Right. But it's really good to have those conversations, not only get the document, but have the conversations with the people you love around you.
Well, it's a good conversation starter, too.
It is, so that people know. And I know that when we actually invoked our living will from my mom, we got no pushback at all. In fact, the neighbors all knew. That's what she wanted. And so it was really easy after we contacted family members who said, no, she absolutely wanted to do that. This is what she wants. and we went to the doctor who was caring for her, and he had no worries whatsoever because she had talked to everybody knew she didn't want to be hooked up to machines forever.
Well, and
I think that's such a great thing because it made it so easy for us.
Well, but in today's day and age, don't you think that's going to change because people are hooked up to their phones? So does there need to be an exception that when you say you don't want to be hooked up to your phone, to machines, but I do want to be buried attached to my phone because I don't know how to function without it?
Well, and I might be texting, in the afterlife. You just don't know. So leave my thumbs in this position so that I'll be ready for the hereafter.
So there are some extra things that we have to consider right now. Okay, so there's the living will, the dead will. What are the other four?
I'm sorry, my side is aching with laughter. Okay.
See, your estate planning can be funny.
Only here. Which is interesting. That's another aside that we should probably explore is how many people have a fear of planning. And we'll talk about that.
We will. Let's do that, yeah.
Let's stay on point. So the significant 7 documents include not only your medical power of attorney, you should have a second power of attorney called a statutory durable business. It's a business power of attorney. You should have what's called a declaration of guardian in case of later need or incapacity on your part, which allows you to designate in advance the fact that you want the same people you named in your medical powers of attorney to be the ones that would be taking care of you if somebody else in your family were to insinuate themselves into your decisions and say, since that car wreck, Patti really can't handle her own affairs and the brain injuries kind of scrambled her brain, and I'm her sister, and I really know what she wants. So, Your Honor, I want you to appoint me as her guardian. And if I'm appointed as Patti's guardian, it wipes out her powers of attorney. So if you have a declaration of guardian now, it keeps family members from trying to insinuate themselves or override your decisions. So you got to have the declaration of guardian.
Right, and in Patti's case, it might not be Aaron, it would probably be me.
Maybe.
Well, there you go. She's still taking votes and collecting opinions.
Yeah, who can pay me the most now?
to manage my affairs later.
Okay, right. So we have 3 more.
Okay. We talked about the directive to physicians. There's another one that's important in Texas. It's called the appointment of an agent to control the disposition of your remains. And that's because once you pass away, you can designate a point person to make all of your arrangements. Well, guess what? If you don't have that document, there's a hierarchy. The default rules in the Texas Estates Code say, then it's going to be next of kin. Next of kin now includes spouse. So maybe I don't need that document. Well, prove you're married. Then you go back to that, how do we know you're married? So you just cut through all of
it's just a quickie document that it just names your spouse.
Yeah, it's 2 pages. It says, I designate the following person to make my arrangements when I'm gone. And you designate spouse first and then an alternate because, we often feel really good about our spouses and want to spend a lot of time with them. We get in cars with them. We take trips with them. And if something, catastrophic were to happen to the both of you, if you've got a document that designates an alternate, then you don't end up back in the default pool where the court says, okay, so all of the siblings get together and make these decisions, or all of the nieces and nephews because you didn't have siblings, or both of your parents, they're divorced and they don't get along well. So you cut through all of this red tape and make it easy on your survivors.
And this is really important because if you feel very strongly that you want to be cremated, for example, but and you don't have this document, and it's possible that someone could insinuate themselves and they say, no, I don't believe in cremation. You must be embalmed and buried.
That's right. Family members can do that.
That's an ultimate decision that'll be out of your hands.
Yep.
So it's a really important document to have.
I agree. They're all key documents to make it easier for your partner, spouse, and easier cutting through the tape, streamlining, and making the process so much easier for your survivors to handle your affairs. So, medical power of attorney, durable power of attorney, declaration of guardian, directive to physicians, appointment of agent to control disposition of remains, a will, That's 6. And then if you want to be an organ donor, there's a designation under the Texas Anatomical Gift Act designation to do that. Because I've had family members go, oh, well, she didn't know that when she renewed her driver's license that was going to make her a donor. She didn't mean to be a donor. Well, if you sign this document in front of witnesses, it's pretty good evidence that you indeed did intend to be a donor. And then if you want to call it a second, 7th, or an 8th document, I always do a standalone hip authorization, which is just a patient privacy waiver, so that no hospital's going to say, yeah, well, you may be the medical agent, but the patient didn't really give us authority to share your medical information with her medical information with anyone. So we just cut through all the tape. That's all it is. It's making it.
So on mine it would be, I want all of my medical information broadcast on Lambda Weekly the following week.
Absolutely. Well, why wait that long? We would do it immediately.
Whatever the next show is. We'll just cut in.
Stay tuned.
We were going to talk about... You just said, and then I said, oh yeah, but let's go do the last...
We have to help David's memory because he's only 25.
It's going. In the 4th decade of my 30s, it's like been terrible. Okay, you just turned it.
I was going to say, we can talk about married and how the definition of marriage might be different depending on where you live.
Oh, okay.
Some states, including Texas, for example, have what's called an informal or common law marriage. And this is a real slippery slope, particularly for people in our community who, for all of their lives, thought that they could have a partner, a significant other, whatever you want to call them, and say, yeah, the old ball and chain, my wife, or whatever, had no legal significance, whatever. It was just a way to say, I'm committed to you and you're committed to me. Or maybe I'm just committed to you and I'm a stalker, but that's another story. So now, saying those kinds of things can have a tremendous impact, because Texas is one of the states that will recognize an informal or common law marriage, which is great if everybody agrees that we got married and we've been married, since 1932. That is how old you are, right? Was it 32?
22.
I'm sorry. So the thing about it is that Texas has the ability for the law to impose a marital relationship on a couple who held themselves out to be married, said to third parties that they were married, lived together as a married couple, and of course agreed to be married. Mm-hmm. So it can't be because somebody just says, yeah, that's my wife, it makes you the wife or the husband. You have to both agree that you're married and that you live together as spouses, and you hold yourselves out to third parties as a married couple.
Now, that can be kind of dangerous for couples that, well, this is Texas, we're never going to be able to get married. They've called each other, this is my husband so-and-so, and then all of a sudden, my other half, using all those terms. This is the wife, Patti, as Aaron usually refers to you.
We don't do that.
She doesn't like to be called the wife.
No. My dad used to call my mom that. And I'll have to check with the wife. I'm like, she has a name, and the wife, like capital T, capital W, TM. It was just, I don't know, anathema to me.
Yeah, but to Aaron, Patti doesn't have a name, so she's just the wife.
By the way, she sent me a little thing with, she's flowing in money. Oh, yeah. That's money.
But all of a sudden, now the couple is splitting up. One of them is the high-income earner. One of them is a low-income earner. And the low-income earner would like to continue living comfortably and can actually sue under common law marriage.
It's happened. It has happened not only in Texas but in other states that do recognize common law marriage, but it has happened in Dallas, it has happened in Austin, in Houston. So there are in fact cases that are working themselves up through the courts. And so if you want your relationship determined by a judge, then that's what happens, is if you do not do one of three things, agree that you're not married, and that's a good way to do that is to have some evidence, because it's all evidence-based. How do you prove that you're married or not married, common law or otherwise? I mean, how do you prove a negative? We're not married, right? So you can have, before you get married, you might want to say, I want that yacht on my side of the ledger. No matter what happens, honey, if something happens to us, the yacht stays in my ledger side. And that's called a prenup. It sets out in advance that what's mine is mine, what's yours is yours, and we are not going to create what's called community property.
And you can do a prenup even if you're not going to nup.
Well, that's where I was going with that. You just absolutely jumped to the conclusion, which is if you're not going to marry, then you can have a no-nup. We used to call them living together agreements because nuptials were not anything that was part of our vocabulary except in jest. So you can have a no-nup, which just says we agree that we're not going to consider ourselves married unless we go down and have, the big marriage wedding ceremony with the Turtle Creek Chorale singing in the background, and all of the
a license
and a license, exactly, and all of the pomp and circumstance that a ceremonial wedding would include. So we agree that we will not hold ourselves out as a married couple unless we do that. So we are living together, and we will split things this way or that way, and you get to write your own rules that way. But if you don't do that, then of course you can fall into the category of one of the partners leaving and saying, I did like the standard of living that I enjoyed while we were together, and so I'm going to have my lawyer sue you and claim that we were common law married and see what the court decides. And then you get into this big, match down at the courthouse. Who's got the best evidence? Oh, in front of other people you said that's my husband or that's my wife. Oh, we have a birthday card you sent and it said this is my wife. Well, it's not because it was, intended as a term of endearment that we are married. It was intended because that was the only card left at the 7-Eleven that night before you got home to say happy birthday. And that's what they had. You tried to scratch it out and it didn't look good, so you went ahead. Anyway.
Or you could end up like the case many years ago with Martina Navratilova.
Exactly,
where they called it
palimony case. Yeah. There were several of those. The court put the kibosh on those. There's no such thing in Texas, unlike California. There's no such thing as palimony. But now, there's no such case that says there's no such thing as common law or informal marriage because it is a strong tradition in Texas.
It's a strong tradition, and it has a very low threshold to prove.
Well, I don't know if you call it high or low. It depends on the facts, but that's the bottom line. It's very fact-intensive. So your relationship and what you've said over the course of your relationship is going to be explored by a judge and possibly a jury to determine the nature of your relationship. Where you could nip all of that in the bud if you would have a little document that either says we are or are not married, And
we are not sharing property.
Correct.
When I say low threshold, you don't actually have to file anything anywhere that says that you're married in order for a court to consider it. In some of the not community property, common law states, you do actually have to file something that says you are presenting yourself.
Well, and you can do that in Texas. If a couple just, abhors thinking about going down and standing before a judge or some, religious officiant and being declared married, they can go down to the courthouse and file as a married couple, and it's called registering an informal marriage, and they're married.
And there have been a couple of cases where a couple has needed to do that because they had to prove they were married 10 years ago in order for one person in the couple to receive pension benefits from the other couple.
But that raises another question, because there were some lawyers who were just friends who happened to be lawyers that were speculating that the way to go if you've been a long-term couple, when the Obergefell decision came and you went down to the courthouse, was to do the informal or common law marriage because you could backdate your marriage. So that
for tax purposes also that would work.
For lots of reasons.
Yeah.
Because that was the avenue to backdate, and I don't even know if that's legal. But but for some purposes, they need to establish that you've been together for 25 years. That would make a bigger difference down the road. And if they got married today with a marriage license, it kind of nullifies that.
Yeah, one couple I know went back and did taxes 3 years back.
That's right.
In order to get back all that tax money that one of them, who was a doctor, spent on insuring her partner, her wife now, and to get a refund on that, because it wasn't income, it was just putting her wife on her insurance policy.
Well, and that's kind of it's evidence, and being able to go down and register yourselves as a married couple, and we have been married and we've held ourselves out to married and lived together as married for 30 years, and I've had a couple that did that. In fact, they've been together over 30 years, and they did exactly that, is evidence. It's evidence of your intention to marry and meet all of the Texas common law rules. And now, with the Obergefell decision, as you said, Patty, some couples go, well, maybe we shouldn't go get a marriage license because it makes it seem like, but that doesn't change anything. If you registered your marriage and said, we married in, 1967, then that's the date of your marriage. The fact that you had an officiant then bless your marriage in 2015, 16, like that, then that doesn't change the fact that you've declared yourselves to be a married couple back in 1967. It's just, to me, just more evidence of your marriage.
Texas is a community property state. How does that affect us?
Well, that's huge, and that's what a lot of couples are coming to realize is it's not just that we wanted to be married, we weren't so keen on falling into the Texas Family Code community property. And that means, what a lot of people don't realize is that means that anything that you generate during your marriage belongs to the community, the both of you, 50-50. So my paycheck goes into the kitty 50-50. Your paycheck goes into the kitty and we own the proceeds 50-50. We buy a car, maybe I put 90% of the money in it and you put 10%. It's owned 50-50 because we've been married. So that's all well and good. Most couples are fine with that. But, what's mine is yours and yours is mine, and what's yours is mine. But the problem
is your nickel and rub it against my nickel. That's what it is.
Okay, so here's, I guess, how it would affect me.
Yeah. Rebecca was going to say the problem with that is, though.
Well, there's many. I think he was.
What I was going to say was, so the one thing that changed after Brian and I got married, a couple of weeks later, I'm reaching for my wallet, and he said, "Oh, I took all the money out of your wallet." And I said, "Why?" He said, "Because I needed it." So with community property, he only owes me half of that back.
That's kind of right.
Oh,
yeah.
Okay. I'll tell
or
him
he had a right to enjoy all of the money that was in your wallet because it's your
ours.
money together.
Right.
So
we need to take a break. You're listening to Lambda Weekly on 89.3 Knon FM. I'm Dave Taffet here in the studio with the late Patti Fink, and we are talking to Rebecca Covell. She's an attorney who does estate planning. We'll be back with more right after this.
I'm Joey Santos, and I listen to KNON FM 89.3 Lambda Weekly.
And welcome back to Lambda Weekly. I'm Dave Taffet here in the studio with the late Patti Fink. We're talking to Rebecca Covell. She's an estate planning attorney, and now, Rebecca, a lot of people have a fear of estate planning. They know they need a will, and it's just a matter of making that appointment with that attorney, and then I have to talk to my attorney about dying.
Yeah, it's a bummer, but it's like taxes. It happens to all of us, death and taxes. And so not thinking about it, the ostrich head in the sand approach doesn't really change the reality of it.
Because so far for millennia, everybody's died except Elvis.
Well, you're right, except Elvis. Well, actually, I think he died and came back, didn't he?
That might be
Was there precedence for that?
It depends on your religion.
Yeah.
If Elvis died and came back. So, a lot of us, they don't want to think about dying because, honestly, they don't want to confront their own mortality. They don't want to think about the fact that maybe the good old days when they retire are not going to be traveling the world because, they've got that trick knee now, or they don't have as much money as they thought they were going to have. And so they don't want to think about it because it preserves that unreality that things are going to be fine as time passes. But it may not easy to think about it, but honestly it happens to all of us. And I think it was somebody from Lambda Legal who says we've spent our lives fighting to live in dignity and make our own choices. Why wouldn't you want to have that right and have your wishes carried out when you're gone? And that's what documents allow you to do. So, just butch up about
dignity in
it.
life, dignity in death.
So,
there you go.
Patty,
Dignity in life,
you need a special line in yours that whatever time your funeral is scheduled for, it will start 30 minutes after that, and your body will then be rolled in them. And not until 30 minutes after.
Well, we'd have to have an appointment of agent to control disposition of remains to carry out her wishes.
Aaron would get me there on time. Sorry.
Aaron will be there on time. You won't be.
Well, there you go.
Yeah.
I can just see it. I'll be wheeling that coffin, and the funeral was set for 11 o'clock. At 11:30, I'll just run in with the coffin, and here she is. Sorry, she was running a little bit late.
Boy, this is really a tough show. And you keep coming back for more, Patti.
I do, week after week.
So I
For
have
55 minutes of it.
You're a good sport.
I am. And I'm still alive.
You are.
So I'm glad you can contribute because we wouldn't want you to phone it in
That's
from the
right.
other side.
But my thumb's ready.
But she's planning on it.
I have had people who have said to me, well, I'm not sure we need to talk about a will anymore because we just got married. Mm-hmm. And I have to remind them that a marriage license is not an estate plan. Mm-hmm. You know, just because you're married, if you do nothing more, all of that means is that you're going to fall into all of the default rules for married couples. So the Estates Code has a bunch of those. And you will be in, I think of it in the long, laboriously long line at the grocery store instead of being in the express lane where you could be 10 items or fewer if you had a will and other documents that made it so easy on your survivors. Because a will allows you to handle all kinds of things. You can designate your spouse as your agent, as your executor at that point. You can designate them as your sole or primary beneficiary. You can decide what happens if you've got, the pets or the fish or the cars or things that you want to go in a certain manner. If you're charitably inclined and you want to donate to, your favorite radio station, for example, you can do all of that if you have a will and other documents. Otherwise, you fall into this big abyss of bureaucratic rules that are set up by the state that your survivors have to go through.
Okay, and so in essence, you're in the self-checkout line with 2 baskets to check out.
Kind of, yes.
I mean, it's going to take a long time.
I was just going to say the Kroger near my house did away with express checkout, and they have self-checkout now. And I can never, no matter where I am, in whatever store, I can't get the Google to work all the time, and I can't get the self-checkout to work. So same thing with this kind of planning. Should you do it yourself off of the internets?
Well, that's a good question. Not the internet. You were so funny. I'm going to stop saying the interwebs.
Yeah.
I'm going to stop saying good question because that was a really pinheaded question.
Go, Rebecca, go.
But there are all of these, fill it out yourself and just fill in the blank things that personally I'm afraid of.
Yeah.
Because
you're a smarter man than I thought. Yeah, go ahead.
But what is wrong? What is wrong with those? Especially for somebody who has a very simple, they don't own much.
Well, that's, as I like to tell people, you want to have a will that works because a will is like a parachute. You only need it once, but you want it to work. Mm-hmm. Are you willing to trust the future of all of your things and your spouse to something you pulled off of the internet? And there are just so many pitfalls because you've got to understand you won't be there to tell the judge what you really meant. And so you got to have it done correctly so that it's enforceable. And having a will does not need to be expensive, but it ought to be done by somebody who knows what in the world they're doing and they can protect you because they've got a license hanging on the wall that they'd like to see staying on the wall. So they're going to be sure the T's are crossed, the I's are the I's are dotted, and that everything is going to go smoothly to make sure that it simplifies your ability to have that will probated.
When you're saying it doesn't have to cost a whole lot, I mean, every will, some wills are, just a couple of pages. Some of them they can go on hundreds of pages. Depends on what you have and how many people you're leaving things. But an average will.
That's always a question. How much is an average car?
There's no average will, but most people can get it done with all their paperwork, most couples, because we're specifically talking about couples here, can get this done for under, or you really
want
don't
a
have
number for me, don't you?
Or do you really not have a number?
I don't have a number, and it's just because I have heard that so many times over the 30 years that I've done this in my practice, where it's just a simple will. They'll call me on the phone and say, it's just a simple will. How much? And I'm saying, if you're asking me how much, you're asking the wrong question. Mm-hmm. It's like kicking a tire on a car. You want to know what the features are, and you need to know, is this going to meet my needs? Am I just, commuting 2 or 3 miles to work, or am I commuting between here and Timbuktu on the other side of Fort Worth? Mm-hmm. So there are so many factors that go into deciding what a good vehicle for you is that you want all of that information before you say, how much is that car? And it's the same about a will.
This is what Aaron and I refer to as all you can order. And I'll tell you where this comes from, because this is kind of a gay story. My sister Eileen, when she used to live here, loved to go down to Oak Lawn with me, and we would sit when we had that store, that special blend, on Cedar Springs, and we would sit outside and have coffee and just people watch. Well, right across the street from there, and I believe it's Havana that's there now, was a little storefront that had been something different every 6 months for a long time. But at one point, it was kind of a mom-and-pop Chinese restaurant. I don't know if you remember that.
The Wok.
The Wok, yes. And we sat out there one day, and they had a vinyl banner across the top of their restaurant that said, "All you can order."
All you can order.
And we just laughed for hours then, because we would see it again, and it would just be all you can order, you know. And like, I had a conversation with a coworker of mine about ties, men's ties, and I had no idea what it is, how that works, you know, like men's ties. What do they cost? What's that about? And I had told him that story years before, and he said, it's kind of an all-you-can-order thing.
Yeah.
You can spend $10, you can spend $400, you can spend $1,000 on a tie. So it's kind of that same thing.
Exactly. So if you're asking how much it is, then you're asking the wrong question. Do you want silk? Do you want cloth? Do you want, leather? Do you want, what kind of interior do you want? So what I do is, I'll tell people that I know it's kind of scary to confront this sometimes, so come talk to me. Let me get more information. I won't charge you my time to sit down and talk to you so that I get a better idea. And once I have a good idea, whether we're looking at a Prius or we're looking at the Mercedes, once I have a good idea on what it is that you need in terms of features, I can say, you and your partner's documents are going to cost X, and I can quote people a flat fee to the dime, what it's going to cost. There's no extra add-ons, for the white walls. They don't do white walls anymore.
So it'd probably be an add-on if you got
Probably be an add-on in my office, too.
So what should somebody, in preparing to come to you, what should they pull together? Specific items that they want left to specific people, all of their accounts, or is a will... Should it be more general so that, you close, one bank gets caught out or bought out by another bank, now I have to change my will because I don't have an account at Bank United anymore, because it doesn't exist.
The thing that I recommend people do is come to that initial meeting prepared to talk in general terms. Do we have to do tax planning? Are you one of those 0.1% that has over $5.4 million per person or per couple? So we have to do tax planning. If not, then we're going to be able to talk in general terms. Wills ought to be the 10,000-foot view rather than getting down into the weeds and say, I have this credit union account and I have this account and that. I don't do that in a will.
Are there ways to avoid probate for certain accounts, like Brian and I can't have a joint account because I saw what he does to one, and we had a household account. Yeah, that didn't work. But we have a system that's worked out. However, if something were to happen to me first, the accounts, of course, all go to him. Should those accounts be structured as payable on death? Should they be structured in a certain way?
Well, that's good, and it's not just a bank account. That's good to have that conversation with Brian, so and it works for you.
He knows.
But so how each of you does with money. That's a conversation you need to have before you say the M word in front of other people. The point is, if you both want to have access to the money and you want it all to go to the survivor when one of you goes, then you ought to have both names on the account now. The second way you can do it, besides a joint account, the second way you can do it is designate it with the beneficiary, and that's your pay on death or TOD.
And that would be for a bank account. An investment account would have a beneficiary. So
life insurance has a beneficiary, and this is kind of cool. Texas is one of the few states, new states, I should say, that now offers, this year, 2016, the ability to have a transfer on death deed for your home.
Really?
Yep. Texas has a transfer on TODD, we call it, transfer on death deed, available for your real estate. So if one of you bought the house and you've been living in it, and you got married, both you and your spouse are living in it, certainly you got to have a will because you might sell that house and get another one, etc. So you've got to have a will to cover these things like a safety net under. You don't want to work without a net. But you could still say, I sure want to make sure that spouse gets this house if something happens to me, and it shouldn't have to go through the probate court, and so I can do a TODD and designate spouse as the beneficiary of that house. It gets filed in the deed records now, and then if I die and we haven't sold that house, or I haven't refinanced it, or I haven't gotten rid of it sometime during our lives, or my life, then the house goes to the spouse. So a TODD is another way to designate a beneficiary for a piece of real estate. It's a really cool process. So yeah, there are a lot of ways that you can kind of avoid the probate process if you need to, but remember this about Texas. We have a very easy probate system. It's not like California or some states where it's extraordinarily expensive and difficult. Or Louisiana. Oh my gosh, the Napoleonic Code. It's just a nightmare.
Yeah,
but if you don't
live in that,
if you don't own property outside of Texas and you're not thinking about buying a place in Arkansas or something, then having a will where you designate each other as the primary beneficiary, streamlined wills like that to be probated in Texas are done very simply. It's a smooth process.
Well, what about Aaron inherited a house in Louisiana?
Yeah.
Do they need special paperwork for Patti to say, I don't want any part of that house? And there's stupid laws. Or if you do have out of state, what do you do then?
Well, what I have often done for couples who have situations like that where they intend to keep the property is we look at trusts. And trust is just a way to hold title to property where Erin can convey that property into a trust that she controls as both the trustee and the beneficiary. She's the settlor, the person who sets it up, settles it. She's the trustee who manages it, and she's the beneficiary. And then you convey title from Erin individually to Erin as the trustee of her trust. Then when she dies, she doesn't own it in Louisiana. Her trust does. And her trust can be the vehicle that names the successor beneficiary to it, and we don't have to go to Louisiana or any other state. So I do trusts oftentimes for lots and lots of people who have second homes or want to have second homes in another state. Buy it in the name of a trust and avoid having to probate in that second state.
And
Good point.
What about debt? Can you leave your debt to somebody? Like, my assets I'm going to leave to Brian, but my debt I'm going to leave to Patti.
Good luck with that.
Yeah, good luck with that.
It doesn't work? No, what about debt, though?
It depends on the kind of debt you're talking about. If it's debt that's attached to an asset like a house, the mortgage on your house, the car loan on your car, the creditor's going to get it. If they don't get paid, then they can foreclose and take, because it's secured by that asset, they can take that asset. If it's credit card debt, medical debt, all this other kind of debt, there's a priority in Texas in the Estates Code that prioritizes debt between classes 1 and 8. And number 1, it starts with the most secured and cost of administration and funeral and last illness and such like that, and it trickles down to the class 8 claims, which are the last ones to be paid, and those are your credit cards. So
if there's money left by the time you get there,
you have to you have to determine what category the debt falls in. But the long and short of it is the debt belongs to the estate of the person who's died. It does not belong to the beneficiaries. It does not get inherited, although the assets don't go until the debt's been paid.
Okay, so
you have to pay hospital expenses first, and if they were in the hospital for a long time before they died.
But let's take the other most common one, just credit card debt.
Right.
Patti and Erin, they have their own separate credit cards. Erin dies. She's been spending Patti's salary, but hasn't told her that her credit card debt is, Patti is then liable for that debt, isn't she? Or
Well, the wrinkle there is, if you're a married couple and both of you were using that credit card, it could be a debt that survives to the surviving spouse. If it was just the deceased spouse's debt and only the deceased spouse used that card, then I think you could probably demand that the credit card company only look to the assets of the deceased spouse, which are going to be that spouse's separate property, and half of all the community assets to pay that credit card debt.
Now, I never heard back on this one, but when when we put him into the Alzheimer's facility, he had a new car, had a car loan, and he had an accident. And I called the loan company. I told them where the car was. They can come pick it up. They said, no, you're liable for the cost of the car. I said, yeah, I don't think so. You're the one who made a loan to a man with Alzheimer's who can't get insurance on a car, so good luck with it. Here's the space that it's parked in. We're selling the condo, and if it's not gone within 2 weeks when the condo closes, I'm having that wrecked car towed. They did come. They did get it. They wanted me to actually drive it to their facility. He was in South Florida. The loan company, because of the way loans sell, was in Alabama. They wanted me to drive the car to Alabama. I said, no. No. If you were in town, I'd be happy to work with you on it, but no. Any repercussions on to somebody inheriting something like that? And I'm saying inheriting because at that point I took over all of his finances.
You, right.
Yeah.
Well, in a situation like that, I think you did exactly the right thing. You got to put the creditor to a choice. Mm-hmm. Do you want the car, or you think you're coming after me? Mm-hmm. And in your case, you said take the car because there are no other assets. And you personally would not be liable for it, but it would have been any other assets in the estate if they chose. You put them to an election of remedies, it's called. So that was the smart thing, is make them choose. What do you want? Yeah. Do you want to try to enforce this debt against his estate, or do you want the car?
I like these terms, election of remedies. Can we just use those in everyday life?
I have some other legal terms that I kind of salt into my cocktail conversations. I talk about incorporeal hereditaments and
you gotta say that
again. Ipsy Dixit. I mean, there's tons of really cool legalese that you can toss in there.
Rebecca, I want to thank you for coming today. This was a lot of fun. Estate planning is a ball. I had so much fun. We need to make an appointment because I don't have all those papers in place. So,
well, thank you for having me. I've enjoyed it.
And we'll be back next week with more Lambda Weekly. See you then. Have a good week.
This is William, hopefully your favorite videographer from Two Hats Publishing. I hope you enjoyed this video. If you like it, please leave comments below, or like, follow, or subscribe to us and get notices of all our videos. We love it, even when you call.